cyber citizens, Cali Joe and friends from North Carolina. I'm Clifton Batch. Cali Joe is unavailable. Today's topic is the root cause of unlawful convictions and the proper solutions to resolve inhumane treatment of the wealthy taking advantage of the poor. In a previous podcast, Cali Joe revealed how he and others, including myself, are denied access to the courts by Clerk Eugene Shore due to North Carolina Supreme Court Justice Paul Newby, which denies pro se inmates court access due to poverty, which is unfair because not everyone can afford a lawyer, and our system does not provide post-conviction counsel, as it states in the general statute. I am fortunate to have been able to meet the one-year Clinton-Biden era 1996 at DEPA. Not many North Carolina inmates are able to, due to various levels of formidable barriers, such as Cali Joe continues to face as Clerk Shore has denied his access to the North Carolina Court of Appeals 4 times since January and twice since mid-July. I myself has been denied by Horn and Shore twice, and the clerk in the North Carolina Court of Appeals by these clerks. And now we have Westlaw digital malfunction. In my unlawful conviction, I refuse to sign or agree to a plea bargain. My counsel failed to listen to my lawful request and strategy. As a black man in a small rural white community with a jury of 12 white people and 1 black alternate jury, I had no choice but to proceed pro se with standby counsel. Because my counsel disregarded pretrial procedures created by our legislator, basically, counsel chose to waive my rights without my consent and issue in North Carolina, where counsel is protected and is shame on me. Such as probable cause where I repeatedly requested but counsel denied, such as my indictment issues. Court and prosecutor failed to correct errors, such as at trial, all I was given was an out-of-date general statute book. And that's it. Because standby counsel was present but unavailable, but for the deficiency resources, I was unable to preserve a Batson challenge. A Batson challenge is when a black guy has 12 white jurors and racial bias may exist. Other procedural defects exist at trial outside the scope and rules of court. In North Carolina, direct appeal, I was appointed appellate counsel Mark Montgomery, a known participant in generate deficient appeals. If you're curious as to how all these situations continue to happen without accountability, Senate President Phil Berger of North Carolina, his real job is a criminal trial lawyer, and since 2001 from Easley to Cooper, nearly every governor was an attorney or related with many lawyers in our legislative branch and in our executive branch. Plus, having Phil Berger's son as a North Carolina Supreme Court Justice, they created rules which undercut accountability. So our legislator and executive was creating perks for those in our judicial branch. So when black and brown are the majority of criminal trial defendants, as most Caucasians take plea bargains, I cannot say if states' unlawful convictions, defective appeals are racially motivated, and Cali Joe only knows 2 white guys that are similar to me. The defective appeals are meant to appear as though we're given on appeal, when in fact they only appeal minute issues that make no difference, such as attorneys, fees, or other issues which the court rule against. However, my appellate counselor knew all my lawful requests, and when he knew I wanted to amend, he quickly amended an issue and stated I couldn't amend anything because he has already amended a clerical error and would not repair his deception. The court ruled against me at that time. Then counsel did a PDR to the North Carolina Supreme Court once more, ignoring my lawful request and knowing he was producing fraud. I dismissed it on my own. Perjury and fraud in our court actions are sanctions, which include procedural bars of dismissal. So I relied upon post-conviction, which the Johnson County Superior Court judge Locke ignored my motions, and it wasn't exhausted, refusing to properly rule on it. I went to rely upon the North Carolina Court of Appeals, but was denied by the clerk, Horn and Soar. I later found out that the Court of Appeal has a pattern and practice of only allowing bar licensed attorneys to file in the court and not pro se inmates. No pro se inmate since 2018 has ever made it past the clerk. Others say 2001, which causes a problem of non-exhaustion, which the Clinton-Biden era, a DEPA 1 year time frame exists for a default in habeas corpus proceedings for failing to exhaust. Having no law libraries, PLS contract stimulates and lacks funding to help prisoners from guard abuse, nor to help with habeas. In fact, we finally got Westlaw Digital Law Libraries in 2023, which as of 3 weeks ago are programmed to log off every 5 to 7 minutes, making research impossible. Thus, I'm able to hire an attorney and I'm able to properly research in violation of Bounds v. Smith and Lewis v. Casey. Gives a state a duty to either provide professional representation or law libraries in person or digital, but with no accountability in our federal court in Raleigh turning a blind eye. By the Myers Court failing to address the petition, only repeating my procedural history and activity in courts such as time frames and rulings, but the North Carolina Office of Attorney General, Surrey Horn Lawrence, only spoke of my defective appeal by Mark Montgomery after pro se post-conviction declining to challenge the petition. Yet Myers held on to the petition for 14 months and failed to use a magistrate judge, while others are given one also failed to discuss exhaustion alone. With my timely adept, Myers is aware of North Carolina Supreme Court Justice newly created rules that prevent pro se inmates access into the Court of Appeals by clerk injection, but would not address it because he too tried to prevent an appeal to the Fourth Circuit by twice bidding in a COA, which is a certificate of appealability. Thankful by this time, I had access to a functional digital West Law Library and knew how to combat such denial. It appears the root cause to unlawful conviction involves North Carolina bar licensed attorneys. The only solution to the problem is to create a database in each state reporting elected officials misconduct, and thus would include designees. Perhaps this election in North Carolina would produce results, because North Carolina Attorney General Josh Stein has failed to report such misconduct of Daniel Horn and Eugene Soar, or even police misconduct in our Court of Appeals. Clerk Denny and pro se inmates assessed to challenge unlawful conviction. Stein is running for governor against Lieutenant Governor Mark Robinson. Is it proper for North Carolina Senate President Phil Berger to use his position of authority for personal gain, using his past and present legal relationships to build a system, while his son Phil Berger Jr. is on our North Carolina Supreme Court to create rules with extended access to pro se inmates? It appears the root cause to unlawful conviction are legislative and executive branch governors since 2001 utilizing their North Carolina bar law degrees to grant perks to those in our judicial branch, creating a pay-to-play system. This is my entering the wrongfully conviction and the procedures and tactics that are used in our court system against black and brown, but not just black and brown, all underclass citizens that are incarcerated, that has the financial burden of being poor and not being able to represent themselves adequately. Thank you.